Hello, everyone, and welcome to today's webinar where we will be learning more about the Equal Pay for Equal Work Act. We are excited to have you all joining us for this important topic and to learn more about what it means for small businesses. Before I introduce our speaker, I'd like to run through just a few logistics. So first of all, we will be recording today's session and we'll send out a follow-up email to everyone with access to the video. Also, we have enabled our questions feature today. It's located on the right-hand side of your GoToWebinar panel. So to get more comfortable using that feature, you can type in your name and where you're tuning in from. We always appreciate to see who is out there. So as questions come up throughout the webinar, we will take some breaks to answer them, and you will have time at the end for any questions we didn't get to. So feel free to type in your questions as they come to you. So I'm Hannah Curtis. I'm a coordinator with the North Metro SBDC, and I'm so excited to introduce to you all Catherine Reynolds, a North Metro legal consultant and lawyer with Polaris Law Group. Catherine, we're so happy to have you today, and I'll turn it over to you now to give us some of your great content.
Thank you so much. So I'm going to start just by giving a little guidance regarding my presentation. At this time, I'm not going to take individual questions as we're going through this. This is just a general guidance on what Colorado's Equal Pay for Equal Work Act is. If you have individual questions, I would recommend either contacting the SBDC and setting up an appointment to talk to a legal consultant, or reaching out to a lawyer to discuss your questions. This is meant to be a guide for you to understand what is coming and to be able to go in and talk to a lawyer. Additionally, this is a brand new law and not much guidance is out there even for lawyers. There will be often times where I will give you the best practices and advice, but it's not necessarily what's legally required because we just don't know yet. We're waiting for the Colorado Department of Labor and Employment, as well as court cases to help us understand some of these statutes. So with that, let's get started. So we're going to talk about Colorado's Equal Pay for Equal Work Act, which is effective January 1st, 2021. Some general things of what we're going to talk about is the why, what, when, who. What does substantially similar work mean? Enforcement, wage audits and transparency, hiring practices and promotions, as well as I'm going to give you some general guidance on how to prevent issues for your company. So why did the legislator pass this law? The Institute for Women's Policy Research and the Women's Foundation found that women in this state earn just 86 cents for every dollar men earn. Latinas earn 53.5 cents, and African American women earn 63.1 cents for every dollar earned by white men. If the wage gap were eliminated, a working woman in Colorado would earn on average $7,000 more per year, which would pay for 1.9 years of community college tuition or approximately 6 months of childcare. The effects of pay disparity compound over a woman's lifetime leads to a woman earning between $4,000 and $1 million in less wages. Equal pay will cut the poverty rate for working women in half and reduce the poverty rate for employed single mothers by 40%. These facts were specifically included in the new legislation as the intent behind this law. So the Equal Pay for Equal Work Act is split into two parts. Each part has different distinct subsections and has different enforcement. We're going to go through part one and then we'll go through part two after that. So the what, when, and who are covered by the law. What is this law trying to prevent? This law prevents pay discrimination of substantially similar work based upon either sex, which includes gender and identity, and or sex plus. Sex plus is sex plus another protected status, such as race, religion, ethnicity, disability, sexual orientation, or age. This is to help prevent the discrimination not only among men and women, but also among white women, African American women, and Hispanic women. When does this law take effect? This law is effective January 1st, 2021, and there is no retroactivity. This law will cover any company that has at least one employee is considered an employer under this law. What does substantially similar work mean? So when a company is trying to determine whether or not there is substantially similar work, you can't just look at the job title. You must actually have to look at the tasks the employee performs and determine if other employees do the exact same work. When constructing this substantially similar work and looking at what your employees do, a couple of easy factors to consider on the skill and effort required for a job, the shift work, as well as job responsibilities. A couple of examples would be the difference between an administrative and a secretary. In the world of law, an administrative assistant will oftentimes schedule meetings, answer calls, send scheduling emails, send bills, that type of stuff. A secretary will do very, very similar tasks, maybe one or two different. In the test of is the work substantially similar, these two are substantially similar, so these two people must be paid the same, even though they have different titles. On the other hand, the administrative assistant versus paralegal could be very different. The administrative assistant does kind of, again, the calls and the answering of emails and voicemails, where a paralegal drafts pleadings, files pleadings, that type of stuff. Those two jobs are different, so then they can be paid different because they do not have substantially similar work. Additionally, the legislator laid out exceptions. You can create a seniority system, a merit-based system, a system that measures earnings by quantity or quality of production, as well as a geographic location where the work is performed. Education, training, or experience to the extent that they are reasonably related to work, as well as travel. So for some of these things, they're really easy to figure out. So seniority system, you can pay your employees who've been there longer more. Merit system, you can pay your better performing employees more. A system measuring earnings by quantity or quality, we kind of consider that commissions. If you pay people based off commissions, that's great. You have a system of doing this. You can pay your employees who are based in the mountains differently than those that are based on the Eastern Plains. If you have employees who have gone and gotten further degrees or training that are reasonably related to their work, you can also pay them higher. A good example of this in our world, in my world of law, is that a paralegal who's gone and gotten a paralegal certificate, you can give them extra pay for having gone and got that education. Finally, travel. If you have a salesperson who's traveling all the time, you can pay them more and still be included in the law. This list is exhaustive. Unlike many laws, there is no catch-all clause. Not only that, an exception is not enough under this new law. An employer must also prove that the employer reasonably relied on the asserted fact, that the asserted fact accounts for the entire wage differential, and that prior wage rate was not relied on to justify a disparity in current wage rate. What that means is if you are giving somebody an increase because of merit, seniority, education, travel, you need to specifically document it, and it needs to specifically align with the difference between employee A and employee B. So if you pay employee A $15 an hour, and then you pay employee B $17 an hour because they have a certificate, and that $2 extra must be just for the certificate. Otherwise, you are not following the new law. Enforcement. There are several ways you can enforce this law. The first one is you can bring a lawsuit in the state of Colorado district courts under this law requesting back pay, reinstatement, promotions and pay increases, attorney's fees and costs, and other equitable relief, as well as liquidated damages. When an employee sues for back pay, they can sue for up to 3 years, but it must be within 2 years of the most recent occurrence. And every time a new discrimination occurs, that timetable ticks forward. So for example, if you have an employee who sues you and has been with you at least 3 years, and they say, look, you have underpaid me $5 an hour for 3 years, you are looking at possibly owing them $31,000 because that's $5 an hour for 40 hours a week, 52 weeks a year, over 3 years. Additionally, where it can get expensive is with liquidated damages. Liquidated damages are available up to the amount of the economic damages unless the employer can show the violation was in good faith. The easiest way to show that the violation was in good faith was by performing a wage audit at least every 2 years. If you can show you are trying to abide by the law and performing these wage audits, then your liquidated damages will be then there will not be awarded a liquidated damages. What that means practically is that as opposed to owing $31,000 in back pay as well as $31,000 in liquidated damages, or $62,000, you would only owe $31,000. There are a couple of other ways that this can be enforced as well. The first one is it can be file a claim with the Colorado Department of Labor and Employment. The CDLE is in the process of creating a way to accept and mediate complaints. However, only the aggrieved employee will be able to put it into the CDLE's mediation process. At that time, the CDLE will be able to award damages to the employee, similar to what you could get in court. We're not sure how this process is going to work or if there's going to be a cap. Oftentimes, currently, the CDLE, when they're dealing with wage disputes, has capped the amount an employee can request and use their process. So there's still a lot of unknowns with how filing a complaint with the Colorado Department of Labor and Employment will work. People can file a discrimination case with the Colorado Civil Rights Division, as well as a federal discrimination case with the U.S. Equal Employment Opportunity Commission. So like I stated previously, the best way to show that you did not your violation was in good faith was to conduct a wage audit. A wage audit must be thorough, complete, and with the specific goal of identifying and remedying underlying pay disparities. Meaning that if your company performs the wage audit correctly, it will be hard to prove that the company did not act in good faith, which then gets rid of that liquidated damages clause. The wage audit cannot be more than 2 years old. So you need to be conducting a wage audit every 2 years in order to get that good faith belief up. Additionally, the statute doesn't explain what a wage audit means, and there's not much guidance out there yet. This will come with time, but at this point, we're just talking about best practices. And finally, when you conduct a wage audit, all benefits and pay are considered wages under this act. So you don't just look at their hourly rate, you look at the benefits you provide them, the 401k, PTO, everything else, and all of that across the board must match. Okay. So some best practices to consider when you are performing a wage audit. And we understand small business owners are very, very busy. If you don't have the time to do this, you can employ either one employee or a couple of employees, and they can do this. But the important thing is that this wage audit is done and done correctly. So when performing a wage audit, we recommend that you review the work each employee performs and determine how much they are paid. At that point, determine if any of your employees have substantially similar work. If none of your employees have substantially similar work, you're kind of done here. But if they do, then you need to move on and determine if any of the employees are paid extra due to any of the listed exceptions. If all of your employees with substantially similar work are paid all the same, you're good. And then you need to ensure that any additional pay or benefit is specifically linked to an exception. Anything not specifically linked to an exception is not okay under this act. At this point, it becomes the step where you compare all employees with substantially similar work, looking specifically at sex and sex plus. So not only do you look at men versus women, but you look at men versus African American women versus white women versus Hispanic women. Additionally, this statute is written so that men can be discriminated against also. So if you have men, you would do the same analysis on the male side. If there is any disparity due to sex or sex plus, you must immediately remedy it. If you fail to remedy your issues, that it can prove a lack of good faith. Finally, as you're going through this process, extensively document all steps you take regarding the wages of each employee. Each of these steps document specifically what occurred, what documents you looked at, how you did your analysis. If you have any questions or are concerned at all about what you see, please contact counsel or other wage audit providers. If you find something that makes you think you might have some discrimination, we highly recommend going and talking to somebody after you've performed these steps. So wage transparency. This is included under the Colorado's Equal Pay for Equal Work Act. Now, this is already current Colorado law, but it is strengthened here. So employers are not allowed to prohibit, as a condition of employment, the disclosure of an employee's wage rate. You may not discharge, discipline, discriminate any employee who inquired, disclosed, or otherwise compared the wage rate. Your employees are allowed to talk about how much they make, how many hours they work, anything related to wages. You cannot prevent them from talking about. You can also not make an employee sign a document that prohibits them from discussing their wage rate or deny them that ability. If you have this in your contract, in any of your employment contracts, in your employee handbooks, and anything else like that, we would highly recommend that you go in, you remove these sections, and you move forward. At this point, the Colorado Equal Pay Act is not effective yet, and there is no retroactivity, so it gives you a time to fix these issues. So hiring practices. The Colorado Equal Pay for Equal Work Act also brings in a few new hiring rules. One of them is that you are no longer allowed to seek the wage history or rely on the wage history of a prospective employee. You may no longer ask what they make or anything related to that. You may also not discriminate or retaliate against a prospective employee for failure to disclose their prior wage rate. This is a big new change that's coming down, so it's just something to keep in mind as you're moving forward. So part 2. So the first part, we kind of separate them out because the first part has much more to do with the discrimination aspect of it. The second part is more of a record keeping and bookkeeping section, but it is important to understand that the remedies for these two parts is very different and how they affect you is different. So opportunities for promotions. This is again another new section of the law that we don't know much about yet. So all employers must make reasonable efforts to announce, post, or otherwise make all opportunities for promotion known to their employees. The announcement needs to be made to all employees simultaneously or the same day, and must be made prior to making a promotion decision. There are a couple ways you can do this. One way would be to send an email to all of your employees. Another way would be to post it online, to post it in the break room, however you can ensure everyone sees it. The advantage of doing it by email is that you have a good record that you have provided your employees this opportunity. At this time, there is no definition as to what all opportunities for promotion entails. The Colorado Department of Labor and Employment is empowered to interpret this definition, but they have not done so yet. So at this time, we are unsure of if a little promotion is allowed or if it's just big promotions. We're hoping the Colorado Department of Labor and Employment will release guidance soon, but it hasn't happened yet, so we're still kind of waiting. Additionally, not only for internal but external job opportunities, there's new regulations around that. Employers are now required to disclose in the job posting the hourly or salary compensation or range of compensation, plus a general description of all benefits and all compensation to be offered. You can no longer say based on past experience. You must get a range. It can be a range something like 40 to 60 plus 401k, health insurance, and paid time off, but you need to be giving that range. The best practice would be not only to include the compensation amount, but also to give an accurate job description and job title. Record keeping. So this is another new part of the statute that's going to affect small business owners. An employer shall keep records of job descriptions and wage rate history for each employee for the duration of the employment plus 2 years after the end of employment. We recommend a couple of best practices for this. We recommend finding a person to be in charge of this process. It can be yourself, it can be a trusted employee, it can be a third party. Just have somebody whose job it is to ensure that your records are up to date. When you go to hire someone, make sure you keep a copy of the job posting, a copy of any notes you have, and then you want to put them in folders. Whether it's online or in paper is 100% up to you, but you want to have each employee should have their own folder with all of this information in it. You want to update the folder as changes are made. We highly recommend doing an annual review with each of your employees and sitting down and talking to them. This will help you not only understand what they're doing, how they're doing, it will allow you the ability to give them feedback. And some of that feedback can be specifically, you are getting a merit increase of this amount because of this. You then want to type all of the information up and have your employee sign it and keep it in your folder. So in the future, if there ever are questions, you can pull out the folder and say, hey, look, this employee made more than this employee because they got a merit increase every single year. They were an outstanding employee. This employee was not an outstanding employee. This is also important if you are sued that you have these records. It's hopefully something that doesn't happen to you, but if you are, the lack of these records can very much hurt your chances of winning in court. So the enforcement for this is a little different than part one. In part one, the employee could sue the employer in court. That is not how part two works. Part two is through the Colorado Department of Labor and Employment. They will be creating and enforcing the rules regarding record keeping and opportunities for promotions. What they will do is if they get a report that you are not keeping your records or providing adequate opportunities internally, they will do an investigation and they will issue a fine of between $500 and $1,000 that will be payable to the state. This is also an important thing to realize, that if an employee brings a suit under the first part of the act, so for discrimination, and they are able to show that you do not have valid records or you did not give opportunities for promotions to all employees via notice, you will not have the good faith obligation on your side. Instead, you can be hit with the liquidated damages. So it's important that employers realize we need to keep their record keeping clean, easy. Additionally, when lawyers are going to sue an employer on this information, we request all of this. So it's very easy for a lawyer to figure out if you are keeping or not keeping all of this information. So, most importantly, how can you prevent issues in your company? Whether you do this, you appoint an HR person, you have an outside third party to do this, these are some general guidance that can help you make sure you're complying with this act. Again, this act is changing, so in a year we might have different guidance, but at this point, here are some things you can do. Develop a system to identify and post future job opportunities, including promotional opportunities. Develop a pay scale and don't vary from the pay scale except in exceptional circumstances. You can, as part of that pay scale, you can create merit and or seniority-based pay or any of the other exceptions. So an example we use is if every year when you go to rate your employees, you give them an A through F. A's get X percentage increase, B's get X percentage, C's get X percentage, then you can show long-term why some employee is making more than another employee, even though they do substantially similar work. Provide employees yearly reviews with explanations of new pay or lack thereof. Ensure all job postings contain a wage rate range. And when you are posting a job, make sure you're saving copies of all of the job postings you're providing. Conduct a pay audit at least every 2 years. Revise your equal employment opportunity policies to conform with this act. Create a policy that prevents inappropriate questions from being asked during the hiring process, and revise record-keeping policies to conform with this act. We understand that this is a lot right now. This is just some guidance to help you get started. And if you have any questions, please reach out to the SBDC. Here is my information, and a lawyer or a third-party consultant can help you navigate these new waters.
Great. Well, thank you, Catherine. That was all really helpful information, explaining all of that. We don't have any questions right now, so for those who are still on, feel free to type your questions in, and we can get to those. And also, as Catherine mentioned, if you do have other questions or would like to set up a consultation appointment with Catherine or any of our other SBDC consultants, you can visit our website, which is northmetrosbdc.com. A great place to go for questions, and also to check out our other upcoming programming, other resources that we have available for free on our website. So feel free to go there. Again, it's northmetrosbdc.com. And we still don't have any questions. So you did a great job covering everything so thoroughly. So thank you all for joining us, and thank you so much, Catherine, for giving us your time today. Do you have anything else you'd like to add?
Nope. We wish you all the best of luck figuring this out. Hopefully some more guidance will come out and we'll be able to give better explanations for some of the unknowns at this point.
Great, great. Well, thank you, Catherine, and thank you all, and we wish you all a great rest of your day.